Your Honor, please. This volume 2F is my another brief note submissions. I wouldn't take more than 10-15 minutes. And before I do that, I thought there's another volume 4D, which I did not refer to the other day.
We don't have that.
It's just volume 4D is a text, except of a book on meaning of meaning. It's about linguistics. I have placed chapter 6 for a interesting reading so that we understand sometimes about definition, how we have some issues. I don't propose to read it at great length. Couple of pages, I may just draw your lots of attention to that. Before I come to that, let me take you lot to volume 2F. We did a little research on the colonial period understanding of intoxicating liquor. And that gives us some insights on how it was understood then. So let me quickly read a few paragraphs of my written note. In the first part, I say that the use and recognition of use of alcohol liquids for other than potable purposes has been a subject matter of discussion during the colonial period. The literature available on this subject gives us insight as to the distinction between classes of alcohol with reference to their uses. It's submitted that entry 8 is based on the said distinction. The literature plays along with this note show that there is nothing in support of the proposition that intoxicating liquor was understood to include all classes of alcohol liquids. Matters of trade and commerce, supply and distribution, etc., referred to in entry 33, or in relation to the products of an industry under the control of the Union. The nature and extent of trade and commerce, etc., will differ from product to product. Clause A of entry 33 of List 3 came in by third constitutional amendment. Enacting such a field of legislation in the concurrent list can be understood from the need for flexible distribution of legislative scope between Union and the states. Entry 33 is therefore a classic example of Article 254 proposition. Once it is understood that neither entry list 2, whichever way it is construed, and keeping in mind entries 26 and 27 of list 2, which are subject to provisions of entry 33, laws made by Parliament under the authority of the two branches, namely entry 50 list 2 and entry 33, will occupy the declared field. The use of the phrase "that is to say" occurring in entry 8 only refers to the range of activities concerning one class of alcohol, namely intoxicating liquor, and is not referable to other classes of liquor, trade, commerce, supply, distribution. These are all activities. The approach adopted in Calcutta Gas based on resolving conflicts between entries in the same list does not appeal to logic. The mere fact that entry 25, gas and gas work, is treated as a distinct entry does not mean that any part of dealing with gas and gas work cannot even conceptually fall under entries 24, 26, and 27 of list 2. The emergence and use of gas processes and industries relating such use can be the only reason for a special attention to be paid to gas and gas works. The logic applied in Calcutta Gas cannot be extended to entry 8 list 2. Now go to the literature in the subject. Let's kindly turn to paragraph
Part 2.
3. It submitted India the use of alcohol for industrial purposes and regulation for both subsequent to use and regulation of alcohol for the purpose of intoxication. To understand the regulation of liquor in India, it needs to be understood that colonial laws of the 19th century were guided by twin objects of generating revenue on the one hand and checking intemperance of people towards safeguarding their morality. The reference is available at footnote number 2. The said purpose of the Akbari Acts, for instance, the Bombay Akbari Act, can be evinced from the contents of the reports and administration of the Abkari Department of the Bombay Presidency, Sindh and Eden. For instance, para 6 of the report of 1880-81 notes progressive increase in Abkari revenue, which is accompanied by decrease in drunkenness. Notably, the details of revenue collections notes 4 branches of Abkari revenue, that's foreign liquor, country liquor, intoxicating liquor, and miscellaneous. That submitted that even though all categories of liquor were considered consumable, intoxicant liquor was considered a separate class of liquor that is ordinarily and regularly consumed, which is administered and monitored separately. In the report of the Administration Abkari Department of the Bombay Presidency, Senate published in 1894, the source of the revenue are listed as 1. The principal source of Abkari revenue on this presidency are A. Manufacture and sale of country liquor, which term is for the present purpose to be understood as exclusive of malt liquors brewed in India, and the special descriptions of liquors referred to under Clause B below. The manufacture and sale of malt liquors and of certain special descriptions of country liquors excise at rates leviable under the Indian Tariff Act on liquors imported from foreign liquors. C, the sale of foreign liquors. D, the manufacture and sale of intoxicating drugs other than opium or preparation of opiums. The country liquor taxed and consumed are two kinds, distilled spirit and toddy or the sap of palm tree. Then next paragraph. The liquor in question during the first century of colonial rule was only the liquor that ordinarily being consumed. It's also worth stating that the alcohol proof prescribed was never as high as 90% proof as is being discussed today. Even as late as 1919, the report on the administration of the Excise Department, Abkari and Opium in the Bombay Presidency, Sinton Aaron notes it para 4. There was no change in the prescribed sales strength of country spirits sold, namely 25%, 30%, so and so. The policy discouraging the consumption of stronger spirit was further pursued, but the restriction, where feasible, of additional shops Then paragraph 7. It was at the turn of the century that alcohol achieved a different dimension. Then turn to paragraph 8. With the increased use of alcohol emerged from the issue of liberal taxation for industrial alcohol and the conundrum that's being faced with the Honorable Court as to what constitutes industrial alcohol. This issue was considered by the Industrial Alcohol Committee in the report of 1920, where it observed we have some difficulty in finding a satisfactory definition of the term industrial alcohol and in avoiding the purely subjective definition of alcohol intended for industrial purposes. At first sight, this would appear to be the only possible description, as there is no intrinsic difference between alcohol intended for portable and non-portable purposes. Possibly the best definition of alcohol, which is exempted from the excise duty leviable on portable spirit on the ground that is intended for non-portable purpose. This will cover both pure alcohol and alcohol, which has been denatured, that is rendered unfit, more or less completely for human consumption. It will also cover the use of alcohol in experiment and research are distinct from purely commercial uses, where the object is to place the finished product on the market by will, exclude the use of alcohol in hospital and in the preparation of medicines and tinctures. Industrial alcohol, as defined above, is alone dealt with this committee. The British Interdepartmental Committee on so-and-so paragraph for the report that all alcohol for power attraction purposes should be described as power alcohol. This is satisfactory so far as it goes. And we have made suggestions for the definition and regulation of such power alcohol. At the same time, they suggest the term industrial alcohol is unsatisfactory on the ground that some sections of the community believe it to be alcohol for the working man. Such misapprehension is not likely to arise in India. Power alcohol is a subdivision of industrial alcohol, and we see no reason to abandon the logical classification. The report also made certain recommendations for preparation, transport, and taxation of power alcohol, that is industrial alcohol, used for fuel or motor vehicles. Then paragraph 5, the report, the final report of it. All local governments should be required to revise the rules regarding other forms of industrial alcohol so as to clearly discriminate from alcohol intended for portable purposes and to provide for grant of special licenses for experiments in the production and use of alcohol, for the use of rectified or specially denatured spirit in industries, and they should also bring their rules into conformity in various minor matters, especially as regards denaturation test, the permissible quantities of private possession and the retail strength of ordinary nature spirit. So that gives us a very important insight as to the pre-colonial understanding and how it has not faded away with intoxicant liquor being treated as an entry in item number entry 8. There are only few observations I want to make. Then constitutional debates, my learned solicitor will extensively deal with that in volume 7. It's also understand the same way. And for instance, CJI talks about it in his volume 2. Industrial intoxicating liquor as meaning liquor which is consumable. And then Justice Sinha notes about it in the judgment. So there are aspects which the solicitor and a friend will deal with. I thought this is an important insight about what happened, which went into the understanding of intoxicating liquor. So if you just also look at volume 4D, that few pages there, the question of difficulty with definitions. It's a very important insight as to how we have all the difficulties in definitions. And the opening page, there's a quote from Oscar Wilde's 4-act play, Lady Winderman's Fan. It's very interesting. So this is how it reads. Do as a concession to my poor rich Lord Darlington, just explain to me what you really mean. I think I had better not, Duchess. Nowadays, to be intelligible is to be found out.
Okay, thank you, Mr. Attorney General. Thank you.
Very well.
Thank you, Mr.
Right.
Yes, Mr. Solicitor.
May I take the Lordship's leave? May I take the Lordship's leave?
Wait, please. But my submissions are in volume 2D.
Volume 2.
2D. There are earlier I have filed 2C, which is modified. So kindly ignore 2C. If possible, technically I'll delete 2C so that there is no confusion. There is nothing,
But yeah, it may be just updated and.
Yes, that's all. There is nothing
There's no
which
duplication.
has wrongly gone into 2C and I'm trying to. This is updated, brought in a little better flow.
So we just said 2C to be ignored.
Yes, 2D. But I would wish to read, my lord, the questions first, and the reason is this. My lord, except one question which directly concerns alcohol as a product. Rest of the questions are on interpretation and interplay between the Constitution of India and the Industrial Development and Regulation Act. Look, though your lordship, my lord, the Chief Justice was right that many of the products are de-licensed now, but many of the products continue to be under the licensing era. Even alcohol partly is under the licensing era. And therefore, whatever your lordship ultimately adjudicates is bound to affect the operation of IDRA vis-a-vis the scheme of the Constitution. And there are certain paramateria entries like 52. Please come to my lord, page PDF page 2. These are the questions. Does section 2 of the IDRA have any impact on the field covered by section 18G of the said Act or entry 33 of list 3 of the 7th schedule? Look, this is a generic question. Does section 18G of the Act falls under entry 52 of list 1 of the 7th schedule or is covered by entry 33 of list 3 thereof? In absence of any notified order by the central government under section 18G of the above Act, is the power of the state legislature in respect of matters enumerated in entry 33 of list 3 ousted? Does the mere enactment of section 18G of the above Act gives rise to a presumption that it was the intention of central government to cover the entire field in respect of entry 33 of list 3 so as to oust the state's competence to legislate in respect of matters relating thereto? Does the mere presence of section 18G of the above Act oust the state's power to legislate in regard to matters falling under entry 33A of list 3? Lord, up to here, these are generic questions, Lord, which would hold the field, my lord, forever till it is doubted or referred something. But IDRA, any scheduled industry being brought under it, would be covered by what your lordships would now decide. And last question, does the interpretation given in synthetics chemicals, that is synthetic 2, in respect of section 18G of the IDRA, correctly state the law regarding the state's power to regulate industrial alcohol as a product of the scheduled industry under entry 33 of list 3 of the 7th schedule of the Constitution in view of clause A thereof? Now, please come to page 3, which are the existing statutes under entry 52 list 1, which would directly be affected by the first questions except the last one. The Coffee Act, Rubber Act, the Rice Milling Industries Act, the Cardamom Act, Coconut Development Act, etc., etc. But this is an illustrative list. There may be other laws also. This is only to point out that kindly do not consider this question only from the prism of alcohol industry. This would be a wider question affecting every schedule industry which is included in the schedule appended to this act. Now, some of the things, which are never pointed out to your lordships right from Tikaramji, and that is why, I would ultimately say Tikaramji is wrong. I'm placing for your lordship's consideration. The first thing, which is never pointed out either in Tikaramji or in any subsequent judgments which follows Tikaramji. None of the judgments, your lordships, had the assistance of these facts, these position in the Constitution. And that is, so just giving an example, Tikaramji says that industry has a restricted meaning it includes manufacturing activities. It doesn't say why. There is no logic, there is no rationale given, there is no discussion. But in the Constituent Assembly debate, Dr. Ambedkar elaborates the term and width of the word industry. So there are 4 compartments in which, your lordships will have to be assisted to reach a correct conclusion. This is not a center state issue. So, this is not an adversarial position. I am taking a position to assist your lordships. Because UP is here, Maharashtra is here, there is nothing political or any federal dispute, etc. So there are 4 stages your lordships will examine in interpreting each entry. First is, called devolution rules. In 1919, Government of India Act was passed.
Yes.
Which bifurcated the subjects between the federal government, which is the central government in the present parlance, and the provinces, that is the state government in the present parlance. That is called devolution rules.
Yes.
Thereafter comes Government of India Act 1935, where again this bifurcation of legislative competence between federal government and the provinces took place. Third is the draft constitution prepared by the drafting committee chaired by Dr. Ambedkar. How they used certain expressions qua each provision and qua each entry. That draft entry or a draft constitutional provision was debated, and how it takes form of what the Constitution is at present. I have attempted to show on every my lord, provision which is coming for your lordship's consideration. All the four. And if your lordships, my lord, would subject to your lordships, my lord, approval, I can say, my lord, if your lordship finds that if this would have been pointed out right from Tikaramji, or at least at some stage, Tikaramji would have been differently decided. My lord, please come to, my lord, page 5, page 6, my lord. But I am skipping what is not, what I have already orally pointed out, my lord. But I come to entry 52 first. Your lordships have, my lord, PDF page 6. My lord justice.
Yeah.
My lord, para 6, I'll read with your lordship's permission. Some of the industries have always been considered to be necessary to remain under the central control if it is found to be in national interest. But throughout, there is a chain of 3 considerations: industry, the functioning of which has a national interest; B, the industry, the functioning of which needs decision making at the pan-India level; and 3, the industry, the functioning of which needs the regulation in such a fashion that the product is equitably distributed. My lord, your lordships are aware, my lord, as we pointed out in mines matters also. My lord, some of the states are endowed with some of the most important resources. Rest of the states do not have the benefit. And if the constitution feels that it is to be left to the parliament, that a particular industry should be centrally governed, not provincially governed, because provincial governments would take provincial provincial perception, and the central government would have a holistic perception. So those industries have always been conventionally, traditionally, and constitutionally be under the center. Lord, now corresponding entry in the devolution rules. The first devolution rules made under Government of India Act 1999. That is
Solicitor, all our young juniors, stand day after day. I've been noticing, with their laptops and in their hand. In the afternoon, the courtmaster will just see if he can accommodate them behind you immediately so that they can sit for the day.
yes, my lord, that's what, my lord, I was saying.
I just told the courtmaster to find out.
My lord, who are not appearing, for example, my lord,
Outside, also we'll see if we can even put some stools or something like that.
No, my lord, some of the councils, my lord, are not appearing in the matter. They can, my lord, perhaps accommodate those who are appearing.
But we'll try and put some additional chairs also for the juniors so that they have
So
they have to be
kind
close
of
to they have to be close to whoever is arguing.
So kind of your lordship, but I am immensely grateful. Lord, entry 20. Lord, this is the route. 1990 Government of India Act. Development of industries in cases where such development by a central authority is declared by order of the Governor General in Council expedient in public interest. My lord, development is underlined by me. It is my emphasis. Now come to, my lord, what happened in 1935. It remains the same. Development of industries where the development under federal control, the word used is now federal control, is declared by federal law to be expedient in the public interest. My lord, federal law is, my lord, earlier version of parliamentary law. Now, my lord, how the drafting committee drafts this entry. Development of industries where development under the control of India is declared by parliament, by law, to be expedient in public interest. It retains, my lord, substantial heart and soul, but makes minor changes. Now, please see, my lord, how it stands today. And there is a reason. The reason is explained in the Constituent Assembly debates. The word development is replaced by the word control. And there is,
interestingly, if you see our constitution, though, of course, we now know it's a federal constitution. That's how we have interpreted. Constitution doesn't use the word federal anywhere at all. Unlike what happened across the border, if you look at the Pakistani, they have used the word federal government, federal. We don't use the word. We have used central, union, but we have not. We have eschewed the word federal in the constitution.
I think, Manoj, this is my
semantics more than anything else, but at least from the birth of the constitution, they didn't use the word federal.
It's my perception, Manoj, subject to your lordship's approval. Lord, the federalism has several facets. Your lordships, I'm not going on general principles of it is quasi-federal and leaning towards unitary, etc. I'm not on that. When it comes to the subjects which need distribution of national resources, but we have, for example, 25 federating units, hypothetical example, 25 states. The classical definition of federalism means each unit is independent in its own way. It's not sovereign the way American states are sovereign, but they are independent in their own way. Any interference by the center may perhaps not breach the element of federalism which is involved in the constitution without naming the term federalism. But now, Lord, kindly see this, Lord, nuance which is my perception. Lord, when the center having an authority under the constitution does something to ensure that 3 or 4 states having incidentally major resources of a particular character do not deprive rest of the provinces, namely federating units, of their right of equal treatment, and the center interferes and makes equitable distribution, that is also an element of federalism. So there, to maintain federalism, the power is conferred upon the center. That now you step in. The only condition is the center must have a backing of a constitutional provision to do so. And entry 52 is one such provision. And it is, in my respectful submission, in furtherance of the principle of federalism. So please see page 7. Industries declared by Parliament by law to be necessary for the purpose of defense or for prosecution of war. I have put it here because entry 24 list 2 mentions entry 7, therefore for immediate reference.
Yes.
And 52, the way Malot ultimately found its place in the constitution as it stands today, industries, the control of which by the union is declared by Parliament by law to be expedient in the public interest. Not the earlier 1919, 35 and the draft used the expression development. Now it is replaced by the word control. And there is a debate. Why are you doing this? Some of the members felt that why are you curtailing the power of the Parliament? And the answer given by Dr. Ambedkar would show that Tikaramji is wrongly decided because this is not pointed out. Tikaramji, in so far as it says that industry is restricted to only manufacturing, is contrary to what the constitutional framers envisaged. Page 7. Let me read this debate, in extenso, because this would have a serious bearing on what ultimately your lordship decides. Honorable Dr. B.R. Ambedkar, sir, I move that for entry 64, 64 is present 52.
Yes.
For entry 64 of list 1, the following entry be substituted. Whenever there is a change in the draft constitution and what is moved, the word used is substituted. Industries the control of which by the union is declared by parliament by law to be expedient in the public interest. Lord, then Lord Kaka Bhagwant Roy, Lord says this, that he moves an amendment in this, that in amendment number 35 of list 1, in the proposed entry 64, that is present 52, the word industries, the word development of industries be substituted. It appears from the amendment which the Honorable Doctor, this is the parliamentary debate. It's not my noting, my note or something.
The Constituent Assembly debate.
The Constituent Assembly debate. I only highlighted. Highlighting is not supply. It
I like the
appears
way
from...
he calls Dr. Ambedkar, the Honorable Doctor.
Yeah, yes.
Deference to Dr. Ambedkar.
To the person, my lord, and the persona. It appears from the amendment which the Honorable Doctor has introduced in the original entry that he wants to hand over all powers regarding industries to the center. It is very good. Center ought to be strong, and during transition, the center should be vested with such powers as are essential for the industrial development of the country. But in normal times, the center should not be vested with such authority. India is a very big country. She has many provinces. These provinces have their own difficulties and can understand their problem much better than the center. The problem of industries is very complicated. Therefore, so far this question is concerned, every province should be given facilities to solve its own problems. If you make the provinces responsible for industrial development and do not give them powers to deal with the situation, then the problem of provinces cannot be solved and it will retard the industrial progress of the country. Although I am somewhat deviating from the point, yet I must say that the present industrial policy of the center will prove a stumbling block in the path of the country's progress. Kindly pause here for a minute. Historically, the first industrial policy came in 1948 when the debates were ongoing. And Lord Kaka Bhagwant Roy was a prominent leader who was opposing that industrial policy per se. Therefore, he says that I am deviating, but I don't agree with the industrial policy. Nothing turns on debates, though. Mr. President, you are only speaking on your amendment, but you are opposing it. Kaka Bhagwan Roy, I bow down to your ruling, but I would like to say that so far industries are concerned, the provinces should be entrusted with necessary powers, for they can understand the problem of their industries better. With these words, I would request the Honorable Doctor to accept the amendment. Then, my Lord, Sri H.V. Kamath comes. I move the amendment as under, that in the amendment 35 of list 1, 6th week, in the proposed entry 64, my Lord, present 52, for the words the control, the words the development and control be substituted.
Yes.
Then he further, sir. Then, my Lord, Mr. Kamath further makes his point before the Constituent Assembly. This amendment includes or embraces the amendment just now moved by Honorable Friend Kaka Bhagwant Roy. The original entry as it stood in draft constitution referred to the development of industries. I wonder why the drafting committee has suddenly developed an antipathy to the word development in this entry. My Lord, Mr. Kamath seems to have a very good sense of sarcasm, my Lord, which will come, my Lord, further. My amendment is on the lines of a legislative measure which was introduced in the Assembly during the last budget session and which has been referred to a select committee. The bill provided for governmental action in industries, the development and control of which was to be regulated by the center, and the title of the bill was Industries Development and Control Bill. That is to say, the subject matter of this entry has been already taken cognizance by the central government in a bill, the title of which includes not merely control, but the development of industries which are deemed necessary or expedient in public interest. Now, he is sarcastic. I realize it is quite possible the drafting committee, owing to the excessive strain under which it had labored during last 2 years and especially during the last few weeks or months, is liable to commit slips here and there. But I hope that the drafting committee has not developed a closed or calcified mind which is not receptive to any change whatsoever. But the sarcasm also, my lord, was with a reasonable degree of respect and restraint.
Yes.
I think that the meaning of this entry will be more adequately and more fully covered by amending this word control on the lines I have suggested and seeking to incorporate in this entry not merely control but also the development of industries, which means industries, the development and control of which by the union is declared by parliament by law to be expedient in public interest. I move amendment so and so. Now, my lord, Dr. Ambedkar answers this, and this is missed. This is the heart and soul of entry 52, which is not assisted with either in Tikaramji or any subsequent judgments which follow Tikaramji, so far as the width of the term industry is concerned.
Yes.
Honorable Dr. B.R. Ambedkar, sir, the entry as it stands is perfectly all right and carries out the intention that the drafting committee has in mind. My submission is that once the center obtained jurisdiction over any particular industry as provided for in this entry, that industry becomes subject to jurisdiction of parliament in all its aspects. Kindly mark this, Malak. In all its aspects, not merely development, but it may be in other aspects. Consequently, we have thought that the best thing is to put the industries first so as to give undoubted jurisdiction to parliament to deal with it in a manner it likes, not necessarily development. Once the industry comes in the first schedule of IDRA, all its aspects are within the control of the central government. And Tikaramji says, no, only manufacturing part. How, why, what rationale, no reasoning, no assistance, and this is completely absent.
At least the view that was given by Dr. Ambedkar, as it appears, was that when the control over industry is given to union, it will cover all aspects and will not be restricted to what is given in Tikaram, that is manufacture. Now, what are the all other aspects? Can we just articulate straight away?
In my respectful submission, this is not from the debates. But when Dr. Ambedkar says that once it comes within the control, all aspects would come in the control, would be right from sourcing the raw material till the distribution of the product. And I'll tell you, Lordship, why. Why, this is my respectful submission. Lord, which are these industries which are intended by the framers of the Constitution to be put under 52? The entries, my lord, as the judgments and the subsequent development goes, where the central government or the center needs equitable distribution and at fair prices. My lord, I'll take your lordships to the...
That is the objective.
No, introduction and the SOR of IDR also, my lord, throws a direct line. And therefore, for example, my lord, taking this example just to answer your lordship's query. But in a given set, I'm sorry, my lord chief.
Yes.
But even given set of facts, my lord, maybe 10 lines, 10 years down the line, or maybe 15 years before, there is a scarcity of sugar, which happened, my lord, during Second World War. The sugar was imported into Britain, and because of the Second World War, all imports were stopped when Churchill took over. Suppose some situation arises. The raw material for production of sugar is sugarcane. If all industries which are dealing with sugar or using sugarcane as a raw material start using sugarcane only for the purpose of, say, making alcohol, and not sugar, the central government can step in. Suppose considering the situation at a national level, the sugarcane growers say that we will not sell the sugar to sugar factories. We will sell only to alcohol factories because we are getting more price. And the interest of the nation is that right now we need production of sugar more because we are deficit in sugar. That's the intention. If that is the intention, then how, my lord, I'm posing a question to myself, we exclude the raw material from the control. Center can do nothing, my lord, in the example which I have given. That country needs sugar, there is a sugar scarcity, sugar production needs to be enhanced, which even Tikaramji says manufacturing is within my control. But the raw material growers, the sugarcane growers say, no, we will sell it to only that factory which makes either potable or non-potable alcohol, because I'm getting more price. The central government can come out with a regulation that no, this is the way in which you will distribute your raw material. You distribute your product, which is a raw material for the industry.
You know, some specific parts of an industry, even after a declaration is made under entry 52 of list 1, is taken out of the scope of entry 52 of list 1 by entry 33 of list 3. So distribution, because entry 33 of list 3 is not a matter of interpretation. It's a constitutional prescription that even after an industry is declared under entry 52 of list 1 as an industry, the control over which is deemed necessary by Parliament in public interest, the central government in public interest. Despite that, entry 33 says trade and commerce and production, supply and distribution of the products of any industry, whether control of such industry by the union is declared by Parliament by law to be expedient in the public interest. So clause A of entry 33 clearly has a reference to entry 52 of list 1, though it does not specifically refer to entry 52, right? Therefore, at least that part, even if it is declared under entry 52 of list 1, that part which falls under entry 33 of list 3
will be
is extracted away from entry 52 of list 1.
No,
and then given to the states as well as the center.
It is added to the term industry as understood in Tikaram. That not just manufacture. You can include product, its distribution, etc. But I just gave an
in fact, entry on a slightly different plane, entry 33 seems to indicate that entry 52 would not otherwise be confined only to manufacture. Because if entry 52 was confined only to manufacture, there was no need to create entry 33. Entry 33 was to carve out something out of entry 52, which would have otherwise been within the fold of entry 52. That's
expanding the 52.
But what it does is, in recognition that entry 52 will cover trade, commerce, production, supply, and distribution, it takes it out of entry 52 and puts it in entry 53.
This is, my lord, since I was answering my lord's question, my lord, my proposition, which I will develop a little later, if I am right and I have understood, my lord, Dr. Ambedkar's understanding correctly, then even in absence of entry 33, my lord, can the Parliament not only under entry 52,
of course,
control everything?
That was Dr. Ambedkar's understanding, but they were not dealing in that part with entry 33 of this.
There is an interesting debate on entry 33 as well. But, my lord, I am putting it in two alternative ways, my lord, for your lordship's consideration. A, please consider entry 52 the way, my lord, in my submission, Dr. Ambedkar understood that everything concerning the industry. Then, my lord, I don't have to fall back on entry 33 list 3 also. Parliament can exclusively under 52 enact a law which takes into consideration right from raw material till end product and its distribution. But alternatively, 33, my lord, as your lord, my lord, the Chief Justice has rightly said, my lord, would come in the aid. And why entry 33 came, lord, I'll assist your lordship.
In fact, part of the IDRA may be traceable to entry 52. Part of the IDRA may be traceable to entry 33 also.
It's a ragbag legislation. That's our argument.
Parliament is also competent under entry 33 to control production, trade and commerce, production, supply and distribution.
But why are we, all of us on this side, my lord, are enamored by the raw material part? Because Tikaramji happened to have that fact situation. Otherwise, there is no doubt that if you control an industry, you control every part of industry, start from finish. But Tikaramji, as a matter of fact, Tikaramji, which is consistently used for a proposition, which it did not decide. I'll come to that. Tikaramji, kindly, just I'm flagging it for your lordship so that it can be kept in mind as per my submission. Tikaramji, the ratio in Tikaramji is merely this. There is an IRDA and there was a state act. Sugar was when Tikaramji was decided a scheduled industry and therefore IRDA applied. The state law concerned sugarcane, and the question was, is there any repugnancy between the central law which governs sugar and the state law which governs sugarcane? The court examined both the acts and says there is no repugnancy. It should have stopped at that. Anything other than that, I'll show, my lord, because unfortunately 1 or 2 paras were cited in Tikaramji, my lord, before your lordships and subsequently also. Everybody has cited 1 or 2 paras without showing, my lord, the background, factual narration, and what exactly is the ratio in Tikaramji. Tikaramji merely says that there is no repugnancy between IDRA and the sugarcane control order of the state government. That's the only ratio. Now, my lord, I'll proceed further, my lord. Page 9, after Dr. Ambedkar's, my lord, reply. My lord, this is accepted, my lord. I need not read it further. Please come, my lord. Page 10.
This argument is accepted. 33.
Kindly come to, my lord, para 10 now. Page 10, para 8. Lord, I have said Tikaramji doesn't take note of this. Lord, I have a separate argument, separate section, how Tikaramji is not a good law, and how Tikaramji's few of the findings are only obiter because it was never called upon to decide that. But that's a separate issue. I'm not, Lord, touching that right now.
production used in entry 33. The word production is used because there are lots of industries which are not covered in any of the lists. For instance, textile industry, leather industry, so on and so forth. So, supposing it is not taken over by the, taken over by.
I agree. Therefore, concurrently,
IDR.
state also
IDR.
can, subject to 33A. If there is a 52 law, state cannot. Otherwise, but state can.
So
Therefore,
what happens
concurrent.
is not, if supposing not the industries are not the ones which are specified in list, perhaps not entry 52 list 1, then the production may also go there. No, there are certain industries specified in list 3 itself. There are certain industries like electricity and other things specified in list 3. Now, where would the production go then? Obviously, it can't go to list 2, it can't go to list 1, it has to go to list 3.
Correct, Manoj.
So that's the reason, Lord, why production is used there. That's all I wanted to clarify, Lord.
Anyway,
Rest
you
we'll
can
explain,
do-
we'll explain
please
Dr.
don't,
Ambedkar's observation.
Yeah, I would request Mr. Trivedi not to-
Therefore, yeah, we quite understand that once an industry is declared as a controlled industry, we use that expression under entry 52, ordinarily everything would be covered by that aspect.
No, there is one more example I can give. The Lordships
Because whether Parliament regulates it or legislates upon it under entry 52 or entry 33 is really, it was one significance. That if Parliament is regulating on those 5 subjects, trade, commerce, production, supply, distribution, then it is regulating only under entry 33. The consequence is, 1, the parliamentary law is supreme. 2, the states can also enact a law.
subject to 254.
Yes, subject to 254. So states can enact the law unless Parliament intended to exclude all power of the states to enact a law under entry 33. Parliament can always do that.
But if there is a law under 52, entry 52, then 33A would denuate the state legislature from
extent.
its power on trade, etc.
That extent.
Yes, to that extent.
No,
Not to that extent.
No. It's to that extent. It's not to that extent.
For trade, correct.
And there's one addition to your written submission which I'll make. Just one phrase. Just 1 second. I was just thinking I'll tell you that at this point. Then there's no problem. Then it's absolutely we are all on one. In your para 8 where you say,
Yes. The restrictive meaning.
Just read that, solicitor, again.
Well, may I read?
Yes.
The restrictive meaning to entry 52 list 1 given in Tikaramji and followed subsequently in subsequent judgments relying upon Tikaramji in absence of being assisted with the crucial constituent assembly debates is thus not a good law. The Parliament under list 1 entry 52 is fully entitled to control everything as per its wisdom, the requirement of particular industry, its wisdom, the requirement of particular industry, and to achieve the stated object of IDRA when Parliament is satisfied that. So this is SOR and the industrial policy.
There I would only make one little addition.
Please.
The Parliament under entry in the list 1 entry 52 and list 3 entry 33. The only thing is that the latter is also subject to state concurrent powers. Subject to Article 254.
Well, that doesn't affect my argument, but hypothetically as an academic question.
Well, once we say that section 18G of the IDRA is traceable because 18G seeks to impose measures on controlling trade and commerce. Not production, trade and commerce. Trade and commerce.
I would, my lord, request for, we never did this.
If a section 18G covers trade and commerce, supply, distribution, all right, then to that extent, section 18G requires a notified order. And in the
Lord, that's a separate argument. There is a separate argument. I have an argument on absence of notified order under 18G, plus 18G is not the only provision which occupies the field under entry 52 read with 33.
And if 18G does not cover production,
there are other provisions. There are other, the entire act is not read before
We'll
your
we'll
lord.
read the act, Mr. Solicitor.
Yes,
All right.
18G is not the
At
only
this
provision.
stage, actually, we'll move forward. At this stage, we wanted to only flag that true, entry 52 on a declaration is comprehensive, the control is comprehensive. But however comprehensive the control on a declaration under entry 52, it will still be subject to entry 53, entry 33. Because entry 33 extracts out of 52 certain aspects, 5 facets, and places it in the concurrent.
Just academically, my lord, to
Because
assist your
clause
lordship.
A of entry 33 is a direct reference to entry 52.
Let us, my lord, leave it at that, my lord. I have
Just look
another.
at it, just look at it, just look at it. Entry 33 says, 33A, so that we have absolute conceptual clarity on this.
Yes.
Now, see, interestingly,
Yes,
entry 52 is not made subject to entry 33,
yes.
right? Because entry 52 has not been made subject to entry 53. But if you now see entry 33, are there any entries in list 1 which are made subject to list 3, by the way?
No, my lord, not to our knowledge, but we'll-
Not, I don't think there's anything like that. Entry 32, right? That property of the union subject to legislation. that is correct. But there's no entry specifically in list 1 which makes it subject to list 3, right?
My learned friend wants me to see property, the union and revenue
Ah.
therefrom, but as regards the property situated in a state, subject to legislation by state, save insofar as parliament by law otherwise provides. So again, parliamentary supremacy.
Now, see, if you look at now entry 50, let's see 52 first.
Yes, 52. Industries, the control of which by the union is declared by parliament by law to be expedient in public interest. Lord, kindly examine the scenario.
Now, Mr. Solicitor, just conceptually, now let us look at 33 for a moment.
You must say not in public interest.
The word,
It's mentioned in the first schedule. And first schedule is only with regard to manufacture or production. But when it comes to 18G, production is not there. There it is control of supply, distribution and price. There is a distinction.
Lord, please bear in mind, 18G is the only section relied upon by them.
you're looking at other sections.
I am going to look at other sections, show other sections also.
Fair enough. But one thing which I wanted to point out to you is this, that entry 33A, the expression, the control of such industry by the union is declared by parliament by law to be expedient in the public interest. These words are bodily the same as entry 52 of list 1. Identical words in entry 52 of list 1, identical words in entry 33 of list 1. These words are identical to those, right?
It's referable to 52.
Right. Therefore, what does 33 say now? Let's read 33.
Trade and commerce in and the production, supply and distribution of the products of any industry where the control of, so scheduled industries, let me.
So,
Scheduled
what this
industry.
means is the moment there's a declaration by Parliament under entry 52 of list 1, entry 33 of list 3 kicks in regard to trade and commerce, production, supply, and distribution. So, entry 33A, in that sense, is a carve out of entry 52 of list 1.
Look, may I put it slightly differently academically? This suits
Then
my
we
eye.
then we can't say that notwithstanding entry 33A, all these aspects, namely trade and commerce, production, supply and distribution, will still be under the exclusive domain of Parliament under entry 52.
Look,
They will still be under the domain of Parliament, but not an exclusive domain.
may I just point out, just examine this. This doesn't change my submission or
That is what.
let's suppose the constitutional framers have chosen to give concurrent jurisdiction on some aspects of a controlled industry under section 33. Lord, kindly visualize a situation academically to test the interpretation. Suppose there would not have been any entry 33, only entry 52.
It would all go under entry 52, undoubtedly.
Then in that case, Lord, right from sourcing the raw material till distribution,
Absolutely. There's
the power.
probably you may be right.
Here, my lord, 33 is given with a view to see that under some circumstances, in absence of a law under 52, the state is also competent how to distribute, how to etc., etc., whatever, how to deal with the product. So therefore, an additional concurrent power is given to the state. I may necessarily not depend upon 33. In absence of 33 also, the power would flow, I mean
Under
parliament,
entry 52.
52.
But when Parliament is enacting a law on the subjects under entry 33, we can't then say that that law is relatable only to entry 52. Then it is within Parliament's legislative competence. Nobody can doubt that the IDRA is within Parliament.
I'm not,
But that part of the law then falls under entry 33. And then we have to see to what extent does that law exclude the power of the states, one, and to what extent that law leaves open some fields for the state. Because that what is left open to the states is after we look at Parliament's legislation. Parliament can legislate on everything under entry 33. We have to then construe that law, IDRA,
I bow.
the area which is left open to the state.
I bow.
If at all some area is left open to the states.
Please see page 10.
Yes.
Lord, these are the 4 contingency Lord, I have formulated. When, my lord, a 52 law
The discussion on entry 33A by Dr. Ambedkar.
it's coming up. It's coming, my lord. Therefore, I have, my lord, my colleagues and my lord, we have worked it on that, my lord, on everything.
That will be very relevant.
Absolutely, my lord. But if your lordship permits, my lord, I may go chronologically, my lord, I have,
Sure, no
so
problem.
that the flow is maintained. That's it.
Absolutely, you can.
So, my lord, when 52 kicks in, my lord, 33 we for the time being, my lord, post it as on the side, my lord, for the time being. The activities of an industry or industries which affects the country as a whole. This is the first condition. Then second, it ought to be governed by economic factors of an all India import and cannot be permitted to be decided by state according to their provincial interests. Planning of future development and sound and balanced national perspective is required to be kept in mind, and to achieve inter alia the object of equitable distribution on pan-India basis at fair prices, the control of all aspects of a particular industry must be taken over. Parliament makes such statutory declaration in the Act. We here, my lord, section 2. Now, my lord, please see para 10. My lord, this is IRDA, the introduction as given in the Act and the statement of objection reasons. Am I with your lordships at page 11?
Yeah, that.
On 6th April 1948, the central government announced its industrial policy, which was approved by the central legislature. Now, this is what was commented upon by one of the honorable members of the assembly, that this is not a correct policy, etc. As per the policy, the development and regulation of a number of important industries, the activities of which affected the country as a whole, and the development of which ought to be governed by economic factors of all India import, were required to be brought under the central control. This is what, my lord, the Parliament says. To achieve this objective, the IDRA bill was introduced in the state legislature. Then, my lord, SOR. The object of this bill is to provide the central government with the means of implementing their industrial policy, which was announced in the resolution number so-and-so dated 6th April 48 and approved by the central legislature. The bill brings under central control and development and regulation of a number of important industries, the activities of which affect the country as a whole. The entire activity, not manufacturing effects, country as a whole, and the development of which must be governed by economic factors of all India import. My lord, the development would necessarily involve right from sourcing raw materials till distribution. It has to be done at an all India level with a national perspective in mind. The planning of future development on sound and balanced lines is sought to be secured by the licensing of all new undertakings by the central government. The bill confers on the government power to make rules for the registration of existing undertakings for regulating the production and development of the industries. Please mark the word production, development of the industries in the schedule, and for consultation with provincial government on these matters. Provision has also been made for constitution of a central advisory council, prior consultation with which will be obligatory before the central government takes certain measures such as revocation of license or taking over the control and management of any industrial concern. Now, my lord, Constituent Assembly debates. Lord, this is the debate dated 5th January 1949. Shyama Prasad Mukherjee. Sir, when clause 2 was inserted as drafted, the idea of the government was that in respect of the entire concurrent list, it should be open to the Dominion legislature. Dominion would be, you mean, my lord, the parliament, the corresponding legislature, to pass laws for the purpose of exercising executive function. At present, so far as the concurrent list is concerned, the Dominion legislature may pass laws which will supersede any laws passed by the provinces. But so far as executive authority goes, it can be discharged only by the provincial governments. In the new constitution under Article 60, which has already been adopted, it has been laid down that even with regard to the concurrent list, it will be open to the Dominion Parliament to pass laws for the purpose of exercising executive function. Well, I'm pausing here for a minute. The law made by the Parliament, implementation at the state government level. Dr. Mukherjee says that he was also Dr. Shyama Prasad Mukherjee, that now for executive function, you have carved out this, you have removed this exception. The question arose whether any such power should be taken over by the Dominion Parliament during the interim period. At present, during the Government of India Act, the Dominion Parliament and the Dominion government can exercise authority in respect of matters which normally fall in the concurrent list in three ways. We have the Essential Supplies Commodities Act, which relates to certain specific commodities such as foodstuffs and certain other commodities in respect of which the Dominion Parliament and the Dominion government have complete legislative and executive powers. The power will lapse in 1951. So please mark this. Secondly, we have a provision which lays down the development of industries which, in the opinion of the Dominion Parliament, is of all India importance, can be taken up by the Dominion Parliament. But that relates only to the development of an industry which may be so described by the Dominion Parliament.
Yes.
I'm sorry.
Actually, Dr. Shyama Prasad Mukherjee has made a very important point that control covers aspects beyond development.
Exactly. That's the respectful submission, which was initially, Manoj, in a different language accepted by Dr. Razak, that we are expanding the meaning of development by using the term control. I'm grateful, Manoj. But only one date your lordships may note, which I forgot. 31st August 49.
But it doesn't come.
The date may be noted, my lord, in the earlier submissions. My lord, when I read Dr. Ambedkar's clarification is 31st of August 1949. The date may have some relevance because on that very day, the discussion about 33 also took place. Therefore,
What is the date?
31st August 1949.
31, so August.
31st August 1949. So now I'll come back, my lord, to
In fact, my
page.
sister, Justice Nagaratna said something very valuable, which is that she said that my learned sister said that control will include development and regulation.
Correct.
Both.
I'm grateful. Lord, I'm grateful. It's a wider term encompassing both. Lord, I was on page 12, my lord. We have
Yes.
Essential Supplies Commodities Act, which relates to certain specific commodities such as foodstuffs and certain other commodities in respect of which the Dominion Parliament and the Dominion Government have complete legislative and executive powers. This power will lapse in 1951. Secondly, we have a provision which lays down that development of industries, which in the opinion of the Dominion Parliament is of all India importance, can be taken up by the Dominion Parliament. But that relates only to the development of an industry which may be so described by the Dominion Parliament. It has been felt that in respect of industrial development, it is not sufficient that Dominion Parliament or the Dominion government should have power only for the purpose of developing industries which are deemed to be of an all India importance. Development has been interpreted to exclude regulation and control. What your ladyship says, which is negative, he is putting it negatively, that it excludes. Development has been interpreted to exclude regulation and control of such industries and also trade and commerce in such industries, control of production and distribution of products of such industries. For that purpose, it was first thought expedient that wide powers might be taken by the Dominion Parliament even during the interim period by a suitable amendment of the Government of India Act. Apart from industrial development, there were certain other matters like statistics, censoring of films, and also industrial disputes in respect of which it was thought desirable that the central government should take adequate powers. So far as industrial and labor disputes are concerned, as has been explained by Sardar Patel, this is a provincial subject, but it has been felt desirable that there should be some uniformity of legislation followed by necessary executive action with regard to industrial tribunals which may be constituted under provincial laws for the purpose of settling disputes. After consultation with provincial government and some of the provincial premiers and representatives of provincial governments who were present in Delhi, it has been deemed desirable that during the interim period, completely wide powers need not be taken over by the Government of India, but a suitable amendment may be made only in respect of those particular items which are now of an urgent character and which require an immediate solution. For this purpose, you will find from amendment number 9 that we have referred to industrial and labor disputes, trade and commerce in and production, supply and distribution of products of industries and development of which is declared by Dominion law to be expedient in public interest. The sanctioning of cinematograph films for exhibition and inquiries and statistics for the purpose of any of the matters in the concurrent legislative list. This will mean a consequential change in clause 7 as originally provided in the bill. The later portion of clause A will be omitted and put in the concurrent list. Now please see, the result will be that so far as legislative powers are concerned, the Dominion Parliament will have ample powers to pass laws wherever necessary, and such laws will supersede provincial laws, if any. So far as the executive authority is concerned in respect of these matters, it will also be open to the Dominion Parliament to pass laws and take over responsibility for executive administration. In case such a step is considered to be desirable or necessary, sir, it is not intended that provincial government should not be utilized for the purpose of coordinating the policy of the central government, even in respect of those matters where central regulation and control are necessary in the interest of the whole country. Obviously, in normal circumstances, the executive machinery which will be utilized will be the provincial governments themselves. But if an occasion arises when it is necessary for the central government to exercise executive authority in respect of matters which are considered to be of an all India importance, power to do so have to be taken over by the Government of India and Dominion Parliament. A question has arisen whether this power should be exercised by the Dominion legislature without consultation with the provincial government. Hitherto, whenever the central government or the Dominion legislature had an occasion to take steps for introducing legislation for development of industries, previous consultation did take place with the provincial government. That was a conventional method, not a statutory mechanism. I believe on a suitable occasion, when the matter comes up a little while later, Sardar Patel will give an assurance on behalf of the government that during the interim period before the new constitution comes into force, if it is necessary for the central government to move in accordance with the powers which are now proposed to be taken under Amendment 9, previous consultation with the provincial government will always be held, and the result of such consultation will be placed before the legislature for information. Now, my Lord, Pandit Govind Vallabh Pant, he saws the seeds of 33A, if I may, Lord, use that expression. Sir, all the four amendments, number 80, 84, 87, and 88, Lord, we have, in the footnote we have given, but your Lordship did not trouble, are interconnected and interlinked, and they must stand or fall together. According to the bill, development of industries where development under Dominion control is declared by Dominion law to be expedient in public interest, regulation and control of such industries, trade and commerce, whether or not within a province, in and production, supply and distribution of products of such industries were to be included in list 1. That is, all these subjects were to be brought within the exclusive jurisdiction of federal legislature and the federal government. Now that would have led to several other difficulties and complications. We all realize that so far as development of industries, where development under Dominion control is declared by Dominion law to be expedient in public interest, and regulation and control of such industries should vest in center. According to the entry already contained in the federal legislative list, development of industries where development under Dominion control is declared by Dominion law to be expedient in public interest is already included, and there is no intention of making any change so far as that is concerned. But as proposed in this amendment, regulation and control of such industries should also be placed under the jurisdiction of federal legislature. So far as the first two parts of this clause are concerned, they will stand as they are, but with respect to the rest, that is trade and commerce, whether or not within a province, in any production, supply and distribution of products of such industries, it is proposed by the series of amendments to which I referred at the outset that these should be included in the concurrent list and consequential changes should be made in other amendments. I think honorable members will agree that amendments that I am proposing will serve the purpose which the original clause had in view fully, and will at the same time avoid other difficulties and complications which might arise if these items were not included in the concurrent list. For by including these in the concurrent list, the power is vested in the center to legislate with regard to these matters. Power is also vested by virtue of clause 2, which has already been amended to appoint agents directly for the administration of any of these subjects, so that the center can have plenary, comprehensive, and if it so chooses, even exclusive control with regard to these matters. But whatever the center may do, I venture to submit that it will still be necessary for the provinces to exercise a number of functions within their own provincial boundaries with regard to these matters. So if these are made the exclusive charge of the center, then the provinces will not be free to discharge the duties and obligations which will necessarily devolve on them. In order to enable the provinces to play their part, subject to the overriding powers that will now vest in the center, it is necessary to include these items in the concurrent list, and that is what I propose. Even now, when we have got the Essential Supplies Act, the central generally frames few basic rules and leaves the rest to the provinces. We in the provinces have been issuing orders, rules and regulations with regard to these matters in our respective provinces. Whatever be the position hereafter, it will still be necessary for the provinces to exercise these powers. In our own province, for example, we propose to introduce a bill so that the distribution of building materials may be regulated, that no steel or iron or coal, etc., be supplied for the purpose of any building which is likely to cost more than rupees 25,000. The raw material for the building. That Pandit Govind Vallabh Pant, subject to correction, was Chief Minister of Uttar Pradesh, the then United Provinces. The cause of a laughter, not, my lord, the subject of laughter. Convey that now you are boring everyone. But how to say that? He immediately found one member in the who was the listener using the hearing aid. So Churchill immediately interrupted the speaker and said that I want to know the name of this honorable member who is denying himself the natural advantage. He has the advantage of removing the hearing aid. Why is he not?
But solicitor, we may accept your submission, we will not accept. But you are not boring because there is always a smile on your face.
I am grateful, Malad. I am grateful. Yes, yes.
And one more thing, after going through your entire submissions, ultimately it all revolves around Tikaram.
Yes, yes, no, Tikaram.
Tikaram is wrong. Ultimately, you will show that. But again, to create laughter, when you criticize Tikaram, you must remember that there is Ram in Tikaram.
Yes, yes, sir. Tikaram ji, Lord, everyone says Tikaram ji.
The entire submissions actually, it will boil down to that.
Correct. Keso Ram also in the earlier matter. Yes.
Consider Tikaram.
I will not be criticizing Tikaram ji, I will be criticizing the judgment. Tikaram ji was right in filing a petition.
Right. Correct.
Judgment was not in his control. And what was argued, or more particularly, what was not argued, was not in his control.
South you would have got.
But I'm on page 16.
No statement by Dr. Ambedkar.
No.
So in your note,
No, 33, something would turn.
Right.
Now, kindly come to 16, only highlighted part.
that's correct.
They require, Dr. Govind Vallabh Pant is advocating that provinces also must be having their say. They require a very extensive network, and I think it is not possible for the center to manage these things without the active cooperation and support of the provinces. So I propose that the amendment to which I referred at the outset be accepted unanimously. But this is how he saw the seeds. Now, please see, Lord, at the foot, I'm not going to read this. This is only for the purpose of completion. Evolution of entry 24 list 2. Industries except 52, to put it, to paraphrase it. Lord, it doesn't, my lord, assist your lordships or the other side either way. So, my lord, I'll not touch that. My lord, please come to page 18, the evolution of 33. And that is crucial, my lord. Let me, Lord, go a little slowly. Lord, as I have said that I am giving 4 stages: devolution rules, Act of 1935, the draft constitution, and the constitution as ultimately, my lord, adopted. How it comes from central list to the concurrent list. That's the journey of 33. The predecessor of 33, my lord, with different language was in central list. But page 18, evolution and constitutional history behind entry 33, list 3. Then devolution rules. It was in entry 19, list 1. Control of production, supply and distribution of any articles in respect of which control by a central authority is declared by rule made by the Governor General in Council or by or under legislation by the Indian legislature to be essential in public interest. Lord, with change of words, it is substantially 52 plus 33. Now, my lord, in Government of India Act, it becomes like this. It comes in list 2 now. Exclusive state domain. Production, I'm sorry.
Yes.
Production, supply and distribution of goods, development of industries, subject to provisions in list 1 with respect to development of certain industries under federal control. Lord, this came in list 2 in 1935 Act. It is substantially the predecessor of 33. That production, supply, etc., subject to list 1, which is under federal control. Now, draft by the drafting committee, my lord, page 19.
Yes.
Draft entry 36. Production, supply, and distribution of goods. Even the draft constitution put it in list 2. Kindly mark that, my lord. The draft constitution also puts it in list 2. Now the Constituent Assembly debates. My lord, kindly, my lord, note here, I've forgotten to note, my lord, it is 31st of August, 1949. When entry 58 was being debated, I'm sorry, when entry 52 was being debated, this was also debated on the same day. Nothing turns on that, but they had both scenario in mind. That's all, my lord. Shibanlal Saxena wanted it to be shifted from list 2 to list 1. It was, my lord, in the draft list 2. Shibanlal Saxena, sir, I beg to move that after entry 64A of list 1, the following new entry be added. The regulation of trade and commerce in and of production, supply, price and distribution of goods, which are the products of industries whose regulation under the control of the Union is declared by Parliament by law to be necessary or expedient in public interest. Of any other goods whose regulation similarly is declared by Parliament by law to be necessary and expedient in public interest. Then he says, Sri Shibanlal Saxena, here I would like to draw the attention of the drafting committee to the fact that a similar suggestion is contained in the recommendations of the Ministry of Industry and Supply, where they have suggested that in the 7th schedule in Union list, such an entry as I have suggested should be provided for. In fact, I may refer to the very page 14 of this booklet containing the comments of the various ministries on the draft constitution. There the ministry states, for effective implementation by the Union Government of the industrial policy announced by the Government of India on 6th April 1948, and for other reasons, it is necessary to invest the Union Government with certain powers over trade and commerce in respect of and the production, supply, price and distribution of goods produced by the industries to be brought under central regulation, and certain other goods such as wholly imported articles or agricultural products. The following additional item is therefore suggested: regulation of trade and commerce in and of production, supply, price and distribution of goods, which are, this is the government suggesting, the then government suggesting. The government is never the then, it's continuity of goods which are the products of the industries whose regulation under the control of the union is declared by parliament by law to be necessary or expedient in public interest. B, of any other goods whose regulation similarly is declared by parliament by law to be necessary or expedient in public interest. Sir, apart from the fact that this amendment has the support of Ministry of Industry and Supply, it should also be obvious to anybody that within the last 4 or 5 years, our experience has shown us that unless there is this power to regulate trade and commerce and also production and distribution, there will be chaos in the country. Even the most important questions of supply of foods and food and clothing and other necessaries of life cannot be tackled on a mere provincial basis, and they must be tackled on an all India scale. So I say this power should be given to the union by means of an adequate provision here in the union list. Otherwise, the center will not have the necessary power. I think it is most important power which should be given to the center. Besides, Mr. President, will it suffice if I point out that there is a proposal for a new entry 35A in the concurrent list that covers this point? I think. Shibanlal Saxena, is it an amendment, sir? Yes, amendment number 142. Then T.T. Krishnamachari. That amendment covers the first part of the honorable member's amendment. Shibanlal Saxena, it is in the concurrent list, of course, but it is not as wide as one that I have suggested. I personally prefer this power to be taken over by center alone. President, very well. Shri Shibanlal Saxena, besides, the words that I have suggested give much larger powers to the center than it is proposed by the amendment in the concurrent list. I suggest the experience of our past 4 or 5 years is sufficient reason for taking this thing in the hands of the center. Sir, I do not think that we should be afraid of investing of center with power in regard to these vital things like food and clothing. Otherwise, I do not think we'll be able to meet the needs of the country in the manner we desire. At present also, the central government has got the power to lay down uniform policies in regard to these matters. But the center should also have the power to make all parts of the country to fall in line with the central policy so as to meet all the needs of the country. And Honorable Dr. B.R. Ambedkar, with regard to the first part of the amendment, there is proposal of the drafting committee to put this matter in the concurrent list.
Yes.
And if my friend Professor Saxena were to examine the concurrent list, he will find that there is an entry corresponding to 64BA in entry 35A. 35A, my lord, is 33, present 33. Then, my lord, 35A, Honorable Dr. B.R. Ambedkar. Sir, I move that after entry 35 of list 2, the following new entry be inserted: trade and commerce in and the production, supply and distribution of products of industries where the control of such industries by the union is declared by parliament by law to be expedient in public interest. So this was accepted. So thereafter comes an amendment, my lord, in 1954. About 4 or 5 items were added.
That is what Mr. Datar said because of Article 369.
Yes,
So for 5 years,
that
Parliament could control
transitory-
some other articles like cattle feed, raw cotton, jute. After
Because
that
it
5
was a-
years, the power would be.
369 was a transitory provision. Thereafter, my lord, this is read. But please see, my lord, the statement of objection reasons of that amendment, my lord. Constitution Third Amendment Act 1954, which amends entry 33. So they must be having a Herculean task, my lord. 1919, 35, then transitory provisions to look at the future. Statement of objection reasons. Entry 33 of the concurrent list enabled Parliament to legislate in respect of products of industries declared to be under the Union control. In addition, Parliament was empowered by Article 369 for a period of 5 years to legislate in respect of certain specified essential commodities. It was not considered advisable that after Article 369 lapsed on 25th January 55, the center should be divested of all legal powers to control the production, supply, and distribution of some of these essential commodities. Specifically, my lord. Then, my lord, addition I may not, my lord, read. Now, my lord, kindly see page 23, because the respectful submission of the other side was about entry 8, list 2, intoxicating liquor. What it means, my lord, the last line first, it only means a beverage having the effect of intoxication. And when we say intoxication,
For that.
commerce in and of production, supply, price, and distribution of goods, which are, this is the government suggesting, the then, my lord, government suggesting. The government is never the then, it's continuity of goods which are the products of the industries whose regulation under the control of the union is declared by Parliament by law to be necessary or expedient in public interest. B, of any other goods whose regulation similarly is declared by Parliament by law to be necessary or expedient in public interest. Sir, apart from the fact that this amendment has the support of Ministry of Industry and Supply, it should also be obvious to anybody that within the last 4 or 5 years, our experience has shown us that unless there is this power to regulate trade and commerce and also production and distribution, there will be chaos in the country. Even the most important questions of supply of foods and food and clothing and other necessaries of life cannot be tackled on a mere provincial basis, and they must be tackled on an all India scale. So I say this power should be given to the union by means of an adequate provision here in the union list. Otherwise, the center will not have the necessary power. I think it is most important power which should be given to the center. Besides, Mr. President, will it suffice if I point out that there is a proposal for a new entry 35A in the concurrent list that covers this point? I think. Shibanlal Saxena, is it an amendment, sir? Yes, amendment number 142. Then T.T. Krishnamachari. That amendment covers the first part of the honorable member's amendment. Shibanlal Saxena, it is in the concurrent list, of course, but it is not as wide as one that I have suggested. I personally prefer this power to be taken over by center alone. President, very well. Shri Shibanlal Saxena, besides, the words that I have suggested give much larger powers to the center than it is proposed by the amendment in the concurrent list. I suggest the experience of our past 4 or 5 years is sufficient reason for taking this thing in the hands of the center. Sir, I do not think that we should be afraid of investing of center with power in regard to these vital things like food and clothing. Otherwise, I do not think we'll be able to meet the needs of the country in the manner we desire. At present also, the central government has got the power to lay down uniform policies in regard to these matters. But the center should also have the power to make all parts of the country to fall in line with the central policy so as to meet all the needs of the country. Honorable Dr. B.R. Ambedkar, with regard to the first part of the amendment, there is proposal of the drafting committee to put this matter in the concurrent list.
Yes.
And if my friend Professor Saxena were to examine the concurrent list, he will find that there is an entry corresponding to 64BA in entry 35A. 35A, my lord, is 33, present 33. Then, my lord, 35A, Honorable Dr. B.R. Ambedkar. Sir, I move that after entry 35 of list 2, the following new entry be inserted. Trade and commerce in and the production, supply and distribution of products of industries where the control of such industries by the union is declared by parliament by law to be expedient in public interest. But this was accepted. But thereafter comes an amendment, my lord, in 1954. About 4 or 5 items were added.
That
Apart
is
from,
what Mr. Datar said, because of Article 369.
yes,
So
yes,
for 5 years,
That
Parliament could control
transitory-
some other articles like cattle feed, raw cotton, jute. After
Because
that
it
5
was a-
years, the power would be.
369 was a transitory provision. Thereafter, my lord, this is read. But please see, my lord, the statement of objection reasons of that amendment, my lord. Constitution 3rd Amendment Act 1954, which amends entry 33. So they must be having a Herculean task, my lord. To 1919, 35, then transitory provisions to look at the future. Statement of objection reasons. Entry 33 of the concurrent list enabled Parliament to legislate in respect of products of industries declared to be under the union control. In addition, Parliament was empowered by Article 369 for a period of 5 years to legislate in respect of certain specified essential commodities. It was not considered advisable that after Article 369 lapsed on 25th January 55, the center should be divested of all legal powers to control the production, supply, and distribution of some of these essential commodities. Specifically, my lord. Then, my lord, addition I may not, my lord, read. Now, my lord, kindly see page 23, because the respectful submission of the other side was about entry 8, list 2, intoxicating liquor. What it means, my lord, the last line first, it only means a beverage having the effect of intoxication. And when we say intoxication, we necessarily say of human being, which is capable of being consumed as it is. If I buy denatured alcohol and do some activity, do some process in it and make it drinkable, it might give me an effect of intoxication, but that is not what is meant in entry 8. It's beverage meant for human consumption for the purpose of intoxication. Two caveats before I will go through that. Number one, what is the import of entry 8 is not a question referred. But when I am before a bench of 9 honorable judges, I can't stand on that technicality. And in any case, the Lordship will have to examine 8 to answer the questions, whether specifically referred or not. And therefore, I have answered it fully. Number two, here, your Lordships are aware, for any product, there are two categories of entry. One general entry, another taxing entry. Here we are not concerned with the taxing entry. They have also not argued, and that's not the question arising. Whoever is taxing whatever, my lord, that continues. Now, my lord, page 23, somewhere in the middle, entry under the devolution rules. Entry 16, provincial subject list. My lord, it was in list 2, my lord, in the present parlance. Excise, that is to say, the control of production, manufacture, possession, transport, purchase, and sale of alcoholic liquor and intoxicating drugs. This is an entry, taxing entry, but we are just trying to understand what constitutional framers understood when they say intoxicating liquor. One thing,
Yes.
one thing your lordships will find as a thread historically, that alcoholic liquor is always spoken of along with other drugs, opium, poison, etc. So in a negative sense, it was considered to be a vice rather than a product. My lord, I'll with respect, my lord, this is what comes out. This is not my personal view, but that is how, my lord, it comes out. So excise, that is to say, the control, production, manufacture, possession, transport, purchase, and sale of alcoholic liquor and intoxicating drugs. Lord, intoxicating drug can be bhang, which comes, Lord, subsequently by name, Lord, Indian hemp. And the levying of excise duties and license fees on or in relation to such articles, but excluding, in the case of opium, control of cultivation, manufacture, and sale of export. So all consumables, alcoholic liquor and intoxicating drugs, which were, opium is also an intoxicating drug, which was excluded. Now, the above referred entry makes the following apparent. Entry 16 in devolution rules is a combined entry both for taxing and other purposes. But thereafter, there is a distinction. But I'm sorry, my lord, kindly pause here for a minute. So far as this entry is concerned, it is a combined entry for regulation as well as for taxation.
Yes.
Which, my lord, gets bifurcated subsequently. Second, at page 24, it covered both potable and non-potable alcohol, and therefore there was no distinction between alcohol for human consumption or intoxicating alcohol and alcohol on one side and remaining alcohols, that is non-potable alcohols, on the other side. Alcohol as a generic word, along with its taxing power, was a subject in the state list under 1919 devolution of devolution rules. Alcoholic liquor. Now, my lord, kindly come to page 24, para 23. Lord, again, my lord, taxing entry, but now it is split in 3 heads. Lord, 2 are taxing and 1 is general. I did not, my lord, elaborate much on taxing entry being different from general entry. Hoyt's and other judgments are very clear, my lord. Lord, this would, I'm sorry, my lord.
Yes.
Lord, this would also give your lordships, my lord, an assistance. Your lordships would have noticed in some of the entries, there are 2 words used, 2 expressions used. One is intoxicating liquor. And in taxing entries, the expression used is alcohol fit for human consumption. Alcoholic liquor for human consumption. Why? We were just wondering why. There are 2 expressions used, but I'll come to that. Now, my lord, Government of India Act 1935, entry 45, list 1. Now, my lord, it comes in list 1. That is the federal government, the central government, so to say, my lord, in present. Duties of excise on tobacco, and other goods manufactured or produced in India, except, now this comes in the exception and therefore goes in second list. So tobacco is central subject. Now please see the expression alcoholic liquors. I'm sorry.
Yes.
First is, kindly see the expression alcoholic liquors for human consumption. Then second, opium, Indian hemp. Indian hemp is bhang. And other narcotic drugs and narcotics and non-narcotic drugs. There are some other non-narcotic drugs having the effect of intoxicating you, but not falling strictly within the definition of narcotic. Then C, medicinal and toilet preparations containing alcohol or any substance included in subparagraph B of this entry. Now, my lord, please see Government of India Act. It is apparent that for the first time, alcoholic liquor for human consumption and other alcohol were bifurcated. For the first time, this bifurcation takes place, which remained till date, my lords. 2. So far as non-potable alcohol is concerned, it was shifted to list 1 as entry 45 of Government of India Act, which is clear from the expression except. Lord, kindly pause here for a minute. Alcohol for human consumption is taken out of entry 1 and given to the provincial entry list 2. Meaning thereby, alcohol not for human consumption, that is non-potable alcohol, is with the center. Now comes, my lord, corresponding entry, my lord, in the state list for taxing purpose. We are not concerned with the taxing power, my lord. I am not arguing taxing power. I am just showing the evolution, how that word is understood. Intoxicating liquor and alcoholic liquor for human consumption. Entry 40, list 2, Government of India Act. Now this is for, my lord, list 2. So state has this, my lord. Duties of excise on the following goods manufactured or produced in the province and countervailing duties at the same or lower rates on similar good manufactured or produced elsewhere in India. A, alcoholic liquors for human consumption. It goes in the state list. According to me, even today, this is there in entry 8 with the state. There is no dispute. Non-potable liquor is with the center. That's, my lord, what ultimately, my lord, I would like to assist your lordships. And similar, my lord, opium, Indian hemp, and other so and so, so and so, so and so. All these 3 exceptions are now in the state list. Para 26. Lord, I can skip that, my lord. Now, please come to page 26. How the drafting committee, my lord, drafted this. Duties of excise
Yes.
duties of excise on tobacco and other goods manufactured or produced in India, except alcoholic liquor for human consumption. Please note, my lord, this is a taxing entry, and therefore the Constitution uses the expression alcoholic liquor for human consumption. B, opium, Indian hemp, and other narcotic drugs and other non-narcotic drugs, but including medicinal and toilet preparations, etc. Now, draft entry 52, list 2. Duties of excise on the following goods manufactured or produced in the province. There were a distinction earlier that produced were not in the province and other than province. The purpose of showing this history is to show that what is intoxicating liquor under entry 8 has always been with the state and non-potable has always been with the center.
But taxing of potable alcohol is with the center.
Yes, no, that comes.
State.
Non-potable, non-potable.
No. Taxing of alcoholic liquor for human consumption, that is with the state.
Yes,
That is with the state.
because it's for the human consumption. But non-potable, by its very definition,
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।